I want to transition, and I really want the viewers to get an idea, because I think for a layperson or someone who finds themselves in family court, the idea of an expert or going through situations where there's DV allegations, domestic violence, parental alienation allegations, and then it's brought up of, we could bring this expert in that'll be able to help us work through these issues and educate the court. So I kind of want to educate the viewers on what you do and how it works in their case. And full disclosure, you and I have never worked together professionally at this point.
We've not.
And we've never had these discussions. I have worked with other professionals. So none of this is scripted, none of it anything. I'm going to be asking honest questions. So
just by way of adding to that disclosure, Mark, if I recall, there's been one case where the client called me and said, I want to hire you as my expert. And I told the client, I don't get hired directly by litigants. I get hired by attorneys. Who's your attorney? And he told me you were his attorney. And,
yes.
and you called me and we talked about my being hired. I don't think I have been hired on that case. So no, we've never worked together. We have no pending cases. And this is all just two independent people thinking and talking out loud.
Yeah, it was kind of funny when he came to me and he's like, hey, I talked to someone and I really want to look into hiring him. I was like, okay, who is it? And then he says your name, and I'm like, ironically, I just emailed him yesterday. I'm trying to get it set up on the show.
That's right. That's exactly right. That's exactly right.
Obviously, so client doesn't go directly to you; it is the attorney. So we'll use my example. I'm the attorney, and we'll obviously, since none of that's moved forward. So I send you an email. I say, hey, Dr. Simon, I have a case where there's parental alienation, domestic violence allegations, all this type of stuff going on. You get retained to come in. What do you do? What is your first step in a case when one side hires you to come in and take a look at what's going on?
The most important thing I want to say up front, Mark, is that when I'm hired to be an expert for one side in a case, is that I undertake an objective, neutral review of the case and formulate my own opinions about the case with no deference to what I might think you would like me to think. Mm-hmm. In other words, I form my opinions independently. I then share. So let's say that you call me and say, I've got a case. I'm defending a domestic violence restraining order. And I'll say to you, please don't tell me anything more about the case, Mark. I don't want to know what's going on in the case. I don't want to know your position. Send me all of the documents that you want me to review to give me the background on the case. Your client's pleadings, the mother's pleadings, anything else that's been submitted to the court or not. Let me review those things, and then let me share with you my thoughts and ideas and opinions about the case once I've done so. Then and only then can you tell me your client's point of view. So the first and most important thing with experts, retained experts, is that they operate with neutrality and with independence. So when I say neutrality, an expert is always neutral to outcome. An expert is not an advocate for the client whose attorney hired them. They're not there to tell the court that client is correct.
Which you don't want. I'll share from chambers. I've had judges call evaluators, call professionals wild cards, loose cannons, and it's in a good way. It means they trust their opinion because they don't answer to anyone.
Well, especially, Mark, when you hire me and your client spends a lot of money to hire me, I know as an expert that I have to overcome a presumption on the part of the other side, and more importantly, on the part of the court, that my opinions have been bought and paid for. Okay. So I have to be extra careful to be scrupulously neutral to outcome, and to educate the court about the issues, not advocate for what the court should do.
Because the other side's going to ask, and you're going to have to be on the record saying you were paid.
I'm typically asked, Dr. Simon, what is your hourly rate and how much have you been paid to date? Okay. Yeah. And I'll quote my hourly rate, and then I'll tell them how much I've been paid to date. And, eyes will roll because people like me are not inexpensive. So you have to be aware that these questions are going to be asked. You need to answer them honestly and directly, and unapologetically. It's also important that you're able to say that you formed your opinions independently. That also means, by the way, so you ask, what happens when you hire me? I tell you, Mark, after you hire me, I'm going to form some opinions. Your client and you, when I form the opinions, may or may not find them helpful. If you find them helpful, you'll probably designate me as your expert witness and call me to the witness stand. If you don't find them helpful, we'll probably shake hands, say goodbye, and maybe I'll hear from you on the next case. But you're probably not going to put me on the witness stand. And I have to be really, really clear that I'm not here to tell you what you want to hear. I'm here to tell you what I really think. Because that's the only thing that I have to assure my credibility. And so the court can, and you want that, because when your client hires me and spends a lot of money on my fees, you want to make sure the court receives the educative testimony well, and that they don't think it's coming from a bought and paid for guy. And unfortunately, there are witnesses whose opinions you can buy. So buyer beware, caveat emptor, always. By the way, that goes particularly true for the DV and the alienation advocates. You can buy their opinions because they only have one.
Yeah.
Yeah. So then sometimes I'm deposed prior to trial, but not always. And sometimes what happens, instead of my being an expert witness, is you may hire me to assist you in preparing your case and putting your case on, in writing questions for experts, in actually assisting you with your advocacy for your client. And I can do that as long as I don't testify or give input to the court in any way.
Yeah.
Okay. One of the more common scenarios is I get a call from a lawyer who says, we just got the report from Dr. Smith, the child custody evaluation from Dr. Smith. We're not happy with the outcome. Can you review this evaluation and let us know what your opinions of it are? And that's a very common entry point for me.
Yeah, that's honestly, I think, in terms of when you get that in California 730 or 3111 back, if it's not favorable, you got to call someone and say, hey, we need to take a look and see, is this sound? What was done wrong? What would we have changed in terms of the evaluation looking back on it?
Well, when you say what was done wrong, you're making a presumption. What, if anything, was done wrong is the right question, because it may not have been done wrong.
Yeah.
It may just be that the opinions of the evaluator about your client aren't pleasing to your client, but they are what they are, and they were arrived at properly. With respect to custody evaluations, let me just add this. There is no such thing as a perfect evaluation. Each and every evaluation has flaws, has strengths. And so whether there's flaws in the evaluation is not the question. The question is whether the flaws amount to very much, whether they matter. Because they're going to be there, because it's a human work product and human beings make mistakes.
Yeah. I completely agree, because you get those what are sometimes 40 and 50 page evaluations. The evaluator a lot of times has spent a lot of time drafting that up, but there's no way it can be perfect.
When I hear you, by the way, when I hear you say 40 to 50 pages, I smile, because in many jurisdictions, reports are 100, 150, 200 pages. Talk about a minefield, right?
I don't know how that's helpful. I don't know how a 40-page evaluation is helpful.
Oh, we can talk about that some other time.
Yeah.
Again, as with most things, there's pluses and minuses.
Yeah, definitely. The nuance piece. But I think mine from the attorney side is, if it's 40 or 50 pages, how much of it is the judge truly taking in when they read it?
That's right. Do they just go to the back of it, read the recommendations, and kind of go home?